Our third panel today is titled, Does Judicial Review Improve Agency Analysis? Moderator is my friend John Cooney. It's a real pleasure to have you here today. John is a partner at Venable LLP, where he's a leading counselor and advocate on regulatory matters. Previously, he served as assistant to the Solicitor General and Deputy General Counsel in the Office of Management and Budget, where he advised the first four OIRA administrators. He is a senior fellow at ACUS. He also chairs the Leadership Council of the American Bar Association's section on administrative law. And so, John, it's a great pleasure to have you here today. The floor is yours.
It's a great pleasure to be here today and see so many old friends and people I've worked with on projects over the years. We're here to look at a very timely study that's been prepared by Reeve Bull, a lawyer, and Jerry Ellig, an economist. His master's voice, Statutory Rulemaking Considerations and Judicial Review of Regulatory Impact Analysis. This is, as I say, an empirical study of how the appellate courts actually have reviewed benefit cost assessments by the agencies. And it's timely because Congress has for a while, and will again later next year, consider how in potential systemic revision of the Administrative Procedure Act, how the issue of benefit cost analysis should be covered, if at all, in that document. We have four brilliant speakers here today to discuss the issues. First, Reeve Bull, the research director of the Administrative Conference of the U.S. and somebody who has tracked the bills pending in Congress on reform of the APA for years, and it's one of the standard reference works that's downloaded for people who are interested in the issue. Reeve was recently elected to membership in the American Law Institute. He co-chairs the E-Rulemaking Committee for the Administrative Law section, which I need to thank him. And he's published numerous articles in prominent law journals, including the Administrative Law Review, one that's published with the help of my section. Second, we have Jerry Ellig, chief economist at the Federal Communications Commission, also from 2001 to 2003, Deputy Director of the Office of Policy Planning at the Federal Trade Commission. So he's an expert in the use of economics in analyzing regs and agency decisions, and comes from an independent agency background. Jerry's also now a senior research fellow at the Mercatus Center, has been since 1996. No, I'm sorry, 1996, and he confesses that he is...
yeah, no, it's been a long time, but not that long.
Right. He has read a... But what Jerry confessed last night is that he's been reading a large number of regulatory impact analyses for the better part of 10 years. And so he has a really good sense of what the agencies have done and how their thinking and the quality of their analysis has changed over time. And he's also been a professor at George Mason itself and at the law school. Third, we have Jennifer New, who's an assistant professor of law at the University of Chicago, specialist in ad law, regulatory policy, and separation of powers, clerked with two of the greats in this area, Judge Richard Posner on the Seventh Circuit and Justice Breyer on the Supreme Court. And perhaps most relevant for today, she has worked at the Office of Information and Regulatory Affairs at OMB, the crucible of regulatory policymaking involving benefit cost assessment, and whose very existence and its track record over the years on trying to set down criteria for appropriate benefit cost analysis has really established cost-benefit review as a formal discipline. And she's a public member of the Administrative Conference of the U.S., chairs the Government Committee on Agency Administration and Management, which I know from prior experience is the price you pay for your sins in a prior incarnation at OIRA. And finally, we have Connor Razzo, another of our independent agency representatives. Connor worked at the Consumer CFPB, and now he's working as senior counsel at the Securities and Exchange Commission. So Connor is on the receiving end of the judicial analyses of cost-benefit analysis. And I think Connor may be able to tell us how the SEC and other agencies have thought about decisions that come down that inform the agencies that their work was not good enough and that they need to do something different in the benefit cost space. Connor's an adjunct professor at Georgetown and Penn Law Schools. Connor has published in the Columbia, Yale, and Administrative Law Reviews, in the Yale Journal of Regulation, which is an enormous accomplishment for somebody who has a day job. I can't imagine how he manages to find the time free in order to do the study and write the articles. And finally, I need to thank him too for his service on the Council of the Administrative Law section of the ABA. For those of you who aren't involved in it, you'll hear that the Administrative Conference of the U.S. or the Administrative Law section is involved in the careers of virtually everybody who's been speaking so far today. And for those of you who might be interested, I encourage you to jump in with both feet, because it's an opportunity for you to meet and socialize with the people who've been up here on the panel today speaking. And with that introduction, I think I'll pass it over, and Reeve, ask if you could start.
Okay, excellent. So first, I would thank John for that great introduction. I think it frames the issues on today's panels perfectly. And I'd echo the other panelists in thanking Adam and Leah for putting together this program, which I think has just been excellent so far. Very, very interesting. So what I'd like to do in my brief remarks is first frame the issue that Jerry and I discuss in our paper and sort of put it within the broader context of what's taking place, particularly on Capitol Hill currently, with various reform initiatives that are underway. And then secondly, I'll briefly go through some of the major findings and sort of how we feel that ties into those reform efforts. So starting out, so as I'm sure you're all very well aware, reg reform has been a major focus in the current Congress. It was also a major focus of various bills introduced by congressional Republicans prior to that point. As John pointed out, we at the Administrative Conference maintain a list of these bills that have been introduced in the last 6 or 7 years. And a major focus of many of them is this question of economic analysis in agencies' regulations. Specifically, several of them would enhance the economic analysis requirements that apply to various federal agencies, some in specific agencies, some in a more cross-cutting way. And then secondly, many of these bills grapple with the question of judicial review. How do the courts go about analyzing what the agencies have done when they look at the economic considerations undergirding a rule? The most famous of which, of course, is the Regulatory Accountability Act, but there are a number of other smaller bills that would similarly deal with economic analysis and the question of judicial review. So that's sort of what's currently underway with respect to reform. I thought it might be useful to just sort of briefly lay out what is the current framework, what are agencies currently doing with respect to economic analysis, and where do these reform efforts fit into that? And I won't spend much time on this because I think everyone in the audience is intimately familiar with this, but I think it's sort of useful to frame the discussion in Jerry and my paper. So first, of course, there's the Executive Order 12866 requirements that are in place and that have been reaffirmed multiple times over the last 35 years. Basically, any economically significant regulation, a regulation that has an economic impact exceeding $100 million annually, has to be accompanied by a regulatory impact analysis, and that's subject to review by OIRA, the Office of Information and Regulatory Affairs. Of course, this only applies to so-called executive branch agencies. The independent agencies like the SEC, the CFTC are exempt from at least this regulatory impact analysis structure. Additionally, several agencies have specific statutory benefit cost analysis requirements. Indeed, that's one of the major things that Jerry and I do in our paper is look at several of these requirements at different agencies and try to classify them by type. And then finally, the courts have played a major role in this arena. In an earlier paper that's forthcoming in the Administrative Law Review, Jerry and I looked at the last 30, 35 years or thereabouts, how the courts have analyzed economic analysis requirements when there's a specific statutory economic analysis requirement in place. What's interesting, though, and where I think the doctrine has evolved a little bit in recent years, is if you look at the Michigan v. EPA case, the majority opinion, and maybe even more so the dissenting opinion, strongly suggests that even in the absence of a statutory economic analysis requirement, agencies are probably required to make some consideration of cost. And if the costs massively outstrip the benefits, there's some suggestion that that's perhaps per se arbitrary and capricious, that somehow that emerges from the APA itself. So I think it's interesting, and the doctrine is evolving, particularly in the courts currently. And I think what Congress is doing has to be perceived within that backdrop. So that's sort of the lay of the land. So what Jerry and I do in this paper is we look at cases in the courts of appeals over the last 35 years or thereabouts that have analyzed agencies' economic analysis under either the arbitrary and capricious or substantial evidence standards of the APA. And we basically look at how the rigor of review and how the type of review has varied depending on what type of analysis requirement is in place. And we classify them into a series of buckets, basically. If you look at the statutes, there are some common verbal formulations that they use. And basically, we look at, for each of those types of verbal formulations, what are the courts doing? How rigorous is their review? We give it sort of an impressionistic score as to how rigorous we perceive it to be, from extremely hard look review on the one hand to very deferential review on the other hand. And we look at how that varies across these 5 or 6 major types of statutory economic analysis requirements. And I think the findings are interesting. On the one hand, I think part of it is about exactly what you would expect. And I think that that's particularly true with respect to the economic analysis standards that are on either end of the spectrum in terms of stringency. So certain statutory standards basically direct the agency to select a particular regulatory alternative, like the least restrictive alternative. Other statutes don't necessarily direct them to select a particular alternative, but they set forth a pretty detailed list of economic benefits and costs that the agency has to consider. Probably the most well-known example is the SEC. Its statute requires the agency to consider the effects on competition and efficiency and capital formation. And what we find is, with respect to these 2 types of standards, either directing the agency to select an alternative or setting forth a detailed set of economic benefits and costs, the level of review is pretty rigorous by the courts. They take the statutory standard very, very seriously. They closely parse the agency's underlying evidence, and then they reach a determination based on that. So that's one end of the spectrum, the more rigorous end of the spectrum. On the other end of the spectrum, there are a handful of statutes that we looked at where it said nothing with respect to consideration of benefits or cost. And in a few of these cases, the agency went ahead and did some sort of benefit cost analysis, presumably because it was required to do so by executive order, or the agency voluntarily chose to do so. And with respect to these, the level of review is very, very generous. The court does not closely parse the agency's evidence. It pretty much defers to the agency's analysis. Very, very deferential standard of review. And this is about what you'd expect. This is not too surprising that when the statutory language is very specific, the courts more closely look at the agency's actions, and when there is no statutory language on point, or when it's very open-ended, then the courts are much, much more generous with respect to their review. What I think is more interesting, though, is if you look at the types of economic analysis standards that stand between those 2 extreme ends of the spectrum, there's quite a bit more variation in the case law. And specifically, the 2 types of standards that I have in mind are, first, the statute will frequently direct the agencies to consider economic cost, and in some cases both economic cost and benefits. And then there's also a common statutory standard where basically Congress directs the agency to consider the economic feasibility of a regulation. And what's interesting here is that you see a much broader array in the cases with respect to the level of rigor of the court's review. So for each of these, both economic cost consideration and economic feasibility, there are a handful of standards where the courts apply type of hard look review that's every bit as rigorous as what you see in the earlier cases that I mentioned. But on the other hand, there are cases applying exactly the same standard where the review is very, very deferential. The agency just makes the court rather just makes sure the agency checked the relevant boxes, and they're really not delving into the underlying evidence or comparing the evidence on both sides, or more thoroughly reviewing the agency's analysis. And so you see a much broader range, basically, in these cases. Another interesting thing is the courts don't seem to focus quite as closely on the statutory language itself in these cases. So as I mentioned, in these economic cost or benefit consideration cases, there are some that refer only to cost. There are some that refer to both costs and benefits. And of course, economic feasibility is another standard entirely, where basically the court is looking at can the market bear the effects of this regulation? Will it bankrupt the industry? And what's interesting is across these three types of standards, there's really not much variation in terms of what the courts are doing. They basically, if it says cost, they'll go ahead and look at the benefits as well. They'll go ahead and look at whether the agency considered alternatives to the regulation that it's imposing. They'll look at the baseline analysis. Basically, they'll look at anything that would go into a regulatory impact analysis, regardless of what the precise statutory language is. So those are basically the two key take-home messages. With respect to these sort of intermediate standards, the rigor of review varies extensively from case to case. And the type of review that the court undertakes is sort of less closely tied to the precise statutory language, particularly when you compare it to statutes that list specific benefits and costs, like the SEC statute. So what does this mean? What's the key take-home message? So I think that basically the main point to take away from the paper with respect to what Congress would consider relevant as to these reforms that I alluded to earlier is that its precision is key. That when you have sort of these extreme ends of the spectrum, the courts basically do about what you would expect. But with respect to these intermediate standards, you see a much broader array of applications. And I think that this would be something that would be problematic both for people who advocate more rigorous review of agencies' economic analysis, as well as opponents of more rigorous review of agencies' economic analysis. Presumably, you'd like to see some consistency one way or the other in terms of what the courts are doing. And what we find is, at least for the economic feasibility and for the economic cost or benefit consideration, there's not that consistency. There's really a wide array of applications that would be troubling for both proponents and opponents. So that's sort of the key message. I guess I'll conclude with just a few caveats that I think need to be borne in mind and that are obviously relevant to sort of what Congress might ultimately do in this area. First, obviously, ideally, it would be perfect. It would be very beneficial if Congress were much more precise as to what it intends. But obviously, there are political considerations that factor into the drafting of the statutory language that may render that infeasible. And in particular, I think that sort of economic cost consideration or economic feasibility may be seen as a compromise standard between sort of the two extreme ends of the spectrum, such that Congress might gravitate more towards these types of standards, even if they lead to somewhat less consistent results overall. But we simply think that this is useful information for Congress to be aware of as it's considering these reforms. Secondly, the sort of precision that we have in mind is probably much easier if it's done on a program-by-program basis or an agency-by-agency basis, as opposed to a cross-cutting standard. But again, whether that's feasible will depend on political considerations. And then the final point I'd note, and allude back to something I mentioned earlier, so I think Michigan v. EPA probably affects the calculus to some extent as well. So I would note that the two cases that we looked at where the statute was silent on benefits and costs, and the court went ahead and looked at the benefit and cost evidence anyway, but was exceedingly deferential, those both preceded Michigan v. EPA. So to the extent that that's changed the calculus, and to the extent that the agencies are now sort of an implicit requirement under the APA, required to consider economic costs and come up with a regulation where the costs aren't wildly disproportionate to the benefits, that, of course, changes the underlying consideration. So mere silence may not be sufficient. Congress may need to be more precise if its goal is that the agency either not consider the economic costs or benefits, or that it do so, but it do so in a way that will lead to a great degree of deference in the courts. So I'll conclude with that. Thank you.
Jerry, we'd love to hear from the economic perspective on this piece.
I'm loading up on caffeine because this might be a snoozer. Okay, well, thanks, John. And despite John's introduction, of course, I have to first say that although I currently work at the FCC, everything I'm saying is, of course, my own views. This is independent of my work at the FCC and does not represent the views of the Commission. Okay, well, Reeve talked about how courts seem to be responding to various types of statutory language that's either more or less specific about how agencies should conduct economic analysis and the extent to which they should use it in decisions. I'm going to talk about how agencies seem to be responding to that kind of language. There's a remarkable parallelism between what courts are doing and what agencies are doing, and it probably has something to do with the fact that agencies like to write rules that will be upheld in court. I mean, if you're an agency, that's a good thing. It's even better to write a rule that has such a strong justification that nobody bothers to challenge it in court. So that's a good thing, and we figure that's part of, as we economists say, part of the agency's objective function. Maybe not the only objective, but certainly something that's important. On the other hand, this has costs. In order to have a good economic analysis, strong justification for a regulation, that requires talent, that requires effort, and those things are scarce resources. Scarce in the economic sense that there isn't enough of them to do all the things that we think might be worth doing. And so agencies have to prioritize and allocate these resources based on where they think they're going to get the best payoff. Our hypothesis is simply that the language of the statute is going to have some effect on how well agencies do economic analysis and how well they explain how they used it, because agencies will allocate resources rationally, and when economic analysis seems to be important under the statutory language, they're going to put forth more effort and devote more talent to doing it well and do a better job explaining it, and when it seems to be less important, they'll do less. It might seem that we're basically proving that water runs downhill. I think in the econometrics I'm going to describe, it does a little bit more than that, because what we're really looking to see is, this is a sensible, rational theory we've got, and undoubtedly it's true to some extent. The question is it true to a great enough extent that you can actually look at some data and see evidence that agencies do this? Or is it just a tiny influence on what they do? And we find it's a noticeable influence on what agencies do. Okay, here's how we test this. We've got 130 economically significant non-budget regulations that were proposed by executive branch agencies between 2008 and 2013 that cleared OIRA review in that time. Why are we using those regulations? Because for other reasons unrelated to this project, those are the regulations that were in a project at the Mercatus Center that we ran called the Regulatory Report Card Project, in which we evaluated the quality of the agency's economic analysis and actually assigned scores evaluating how well the agency assessed the problem that it's trying to solve, the benefits of the regulation, the costs of the regulation, and the benefits and costs of the alternatives. We also looked at the NPRM to see how well did the agency explain any way it might have used the analysis, and to what extent did net benefits, the difference between benefits and cost, have any kind of a role in the agency's decisions. And in fact, in many cases, the agencies were silent on these kind of things. You might expect a lot of false positives because agencies would always claim they used the analysis in order to get it through OIRA. In reality, they often don't say anything. But in any case, so those are our indicators of how good the analysis is and how well the agency explained that it's used it. This is not the same sample of cases that Reeve was talking about, because that part of the paper looks at cases that actually, regulations that were challenged and went through the courts, and there were only 30 some of them. We've got 130 regulations that we can take a look at. So we have these regulations evaluated. We can also indicate for every regulation which bucket it falls in, or sometimes they fall in multiple buckets, in terms of what kind of requirements are in the statute relevant to economic analysis. In some cases, the statute says you have to consider these types of benefits and costs when you issue a regulation and determine that it's somehow economically justified. In other cases, it's more a broad, consider benefits and costs somehow. In other cases, it's just consider the economic feasibility or consider the technological feasibility. And in some cases, agencies are prohibited from considering costs. And then there's another group, which is kind of our basis for comparison, which is where the statute is silent. It doesn't prohibit them from considering anything, doesn't tell them they have to consider economics or how to do it either. And so when I say in a few minutes that in certain cases we found the analysis was better or worse, what I mean is our reference group for comparison is the group where the statute is silent. So I'll be saying, it's better than when the statute is silent, or worse than when the statute is silent, or about the same. Okay. So we've got the variables we are trying to explain, which is the quality of the analysis and the extent to which it's explained, its use is explained. And we've got these regulations categorized based on the statutory language, and that's the explanatory variables we hope are going to be important. And then we've also got a big slug of control variables that we're putting in the regression analysis, which I won't talk any further about. But these are control variables that I've used in a bunch of other studies using this kind of data for other reasons. And in many cases, they've had some significant effect on the quality of analysis. So we put those in to make sure that we're not attributing some effect to the statute that's really maybe being caused by something else. The score variables that we have are ordinal, not cardinal. So the appropriate econometric method is ordered logit, and since ordered logit may not yield consistent estimates in a small sample size, the best method is to use something called blow-up and cluster ordered logit that was invented by 3 German guys whose name I can't pronounce a few years ago. Now, for those of you who are not statistical mavens, if what I just said was gibberish, I'll say three things. 1, trust me. 2, the relevant sources that justify how we do the econometrics are all in the footnotes of the paper, and anybody can check that. 3, I've used these data for other purposes and other studies, and I've been beaten up enough by economics journal referees to know that the way we're doing it in this paper is probably the best way to do it. Okay, so what are the results when we look at this? In cases where the statute says the agency has to figure out whether a regulation is economically justified, and it actually lists some of the benefits and cost factors the agency has to consider. That's probably the most specific kind of statute that you can get. In those cases, we find, after controlling for other factors in the regression, we find better analysis of benefits, better analysis of costs, better analysis of alternatives, better explanations of how the agency used the analysis, and better explanations specifically of how the net benefits of the regulation affected the decisions. Interestingly, there is some evidence, although it's weak, that also for those regulations, you have worse analysis of the underlying problem the agency is trying to solve, which is the one thing the statute didn't tell the agency to do. Okay, moving to like the next weakest form of statutory requirement. A requirement that the agency has to consider the benefits and costs, somehow. For those regulations, compared to when the statute is silent, we see better analysis of the benefits and costs of alternatives, no better analysis of the benefits and costs of the regulation that was adopted, and better explanations of how the analysis affected decisions. So when the agency has to consider benefits and costs but has a lot of leeway to do it, the analysis is somewhat better and somewhat better explained, but not as much as when the agency has to consider specific benefit and cost factors. And we go further down the line. When the requirement is only a consideration of economic feasibility, you get a little bit better analysis of costs. You get worse analysis of the underlying problem the agency's trying to solve. And the other stuff is the same as if the statute's silent. When consideration of costs is prohibited, you get worse analysis of costs. I mean, it makes sense, right? If they're not allowed to consider costs, the agency won't do as good a cost analysis. Also, though, you get worse explanations of how the analysis affected the decisions and possibly somewhat better analysis of the underlying problem. And then finally, when the requirement is a technological feasibility requirement, you get worse analysis of alternatives and worse analysis of costs and worse explanation of how net benefits affected the result. So these results are pretty consistent if you recall what Reeves said the courts are doing, where courts will scrutinize an agency's economic analysis and its justification for the regulation more carefully when the statute is more specific. Well, agencies, now this is only correlation, not causation, but agencies are behaving as if they are trying to make sure that their regulations can't be overturned by doing better analysis and offering better explanations in precisely the kinds of situations where it appears that courts are going to look more carefully at the economic analysis and look more carefully at the regulation. Now, I'm not going to repeat the kind of implications that Reeve mentioned for regulatory reform, but I want to mention one other, and that's this. Stuart Shapiro, who's a political scientist up at Rutgers, he's one of the leading students of how various kinds of analysis are used in federal agencies. Economic analysis, risk assessments, environmental analysis, all this kind of stuff. And he wrote something a couple of years ago that argued that Congress is in the habit of periodically passing regulatory reforms that don't accomplish much because the political compromise that occurs to get it passed is we pass a reform that sounds good, but there's really a weak enforcement mechanism or no enforcement mechanism. And so I think the other implication that falls out of this research that we're doing is that if folks in Congress are writing regulatory reform legislation and they want it to make a difference, it should be specific. It should allow some kind of enforcement mechanism like judicial review. And if compromises are necessary to get it passed, can't imagine why. Now, if compromises are necessary to get it passed, find some other way to compromise to get it passed rather than taking out the enforcement mechanism. And I don't know where we are on time, but I'm done.
Thank you very much, Jerry. As he mentioned, there's a third player that is interested in the quality of the regulatory analysis and the cost-benefit equations that are studied, and that's in addition to the courts and the agencies themselves, it's the Office of Information and Regulatory Affairs at OMB. And Jennifer's going to talk some about the general topic and specifically about OIRA review and what it does with benefit cost analysis.
Great. So this is a study with a really happy punchline, right? And it's essentially this, that agencies follow the law, at least as understood as statutes passed by Congress, right? So more specifically, Jerry and Reeve show us that when statutes are drafted to require the agencies to consider costs and benefits, more so when they're enumerated costs and benefits, agencies do so. And while their main audience is Congress, it could just as easily have been the courts, right? In other words, it could have been a paper whose punchline essentially read, when faced with a statute that's ambiguous, take the SEC's statute calling for efficiency, capital formation, and competition, courts should use what has been called a cost-benefit analysis canon of interpretation. That is, interpret it in favor of requiring cost-benefit analysis. In my brief remarks today, I want to talk about three other potential audiences for the paper. In particular, I want to talk about first the audience of agency leadership, if your goal is increasing the quality of cost-benefit analyses. The second is indeed the Office of Information Regulatory Affairs, or OIRA, as many insiders refer to it. And three, those involved in the budgetary process. That is, those that are in charge of thinking about the resources for an agency, for staffing up an agency, and how to staff these agencies. And in doing so, what I hope to do for a general audience like this is really to thicken our conception of cost-benefit analysis as a political practice, rather than something that is just in the realm of economists, fancy as they are. I think it's also very much a political endeavor, and it's important to understand the identity of the political actors in that government practice. Okay, so first, beginning at the agencies. Of course, CBA drafting practices vary by agency, but I think it is possible to generally describe how the internal process works in many agencies. Often, rules are written by rule-writing teams within agencies, and they're staffed by many people who could have a hand in drafting these CBAs. They include agency economists, they include agency lawyers, often from the General Counsel's office or an office of rulemaking, and they're also often contracted out to private firms. And once the initial cost-benefit analysis is drafted by career staff members, there's often an office within the agency that serves as, if you will, a mini OIRA within the agency. So for example, in the Environmental Protection Agency, there's the Office of Policy's National Center for Environmental Economics that reviews the CBAs drafted by the career staff. Also note that the Securities Exchange Commission, the General Counsel issued, on behalf of their mini OIRA, I think, the Division of Risk, Strategy, and Financial Innovation, which has gone through many iterations, and perhaps Connor can tell us about its current form, promulgated guidance post-business roundtable on economic analysis. Okay, so note, this is huge, right? This is an independent agency adopting the principles of these executive orders that have gone back decades, explicitly reference Circular A4, which is the main sort of guidance document governing the cost-benefit analysis review at the executive agencies, and issues this on behalf of all its rule writing, or for, rather, all of its rule writing offices. And indeed, a recent Inspector General reports finds that this guidance document had an effect. That is to say, it increased the quality of the cost-benefit analyses being issued by the SEC. Okay, so in other words, again, one punchline here is, if you want to increase cost-benefit analysis quality, don't forget about agency leadership, agency executives. Second, OIRA and the OIRA review process. So, for those of you that aren't familiar with this process, I want to just describe it generally. There are many nuances that I'm sure Jim Tazi or Dave Rosker or other former OIRANs here could tell you more about. But I want to explode the idea that I think is common in some of the law review literature, sometimes in just colloquial discussions of OIRA, that OIRA is some phalanx of economists that just drafts cost-benefit analyses, or gets its hands dirty with all of them. I think a more accurate picture is to understand that how the process works is for draft proposed final rules that are significant, often they are assigned to a desk officer within the agency that are in different offices and branches that are subject matter specific within the agency, and they're essentially in charge of coordinating the review amongst a number of different actors, okay, including, of course, OIRA's own economists, but in addition to that, many actors within the Executive Office of the President, right, including economists at other agencies, including the Council of Economic Advisors, the National Economic Council. The point being that there are many economists outside of the agency that are also lending a hand to review. And so to the extent that your interest is in increasing cost-benefit analysis quality, OIRA has a number of different tacks that it could take to facilitate that. For starters, it could, to take a lesson from the paper, try to issue more specific guidance, issue rules rather than the existing standards under their executive order about what cost-benefit analyses should look like. In other words, it could be much more specific about the kind of factors that agencies have to consider beyond the loose standard that currently exists under the executive order to consider things like dignity, equity, fairness. I mean, these are all important considerations, surely, but it could be more specific if it wanted to be. In addition to that, it could increase the definition or make it even more expansive in terms of significant rules to bring under its review a greater number of those regulations. And then academics, too, I think, could do more to test exactly the impact that OIRA has had on cost-benefit analysis. And there are a number of different ways one could do that. You could use as a control group all the regulations that preceded either EO 12991 or 12866, and see if there's a difference. You could also use as a control group the cost-benefit analyses of independent agencies as well. Finally, of course, cost-benefit analyses and drafting them is, as Jerry pointed out, an expensive endeavor. One CBO study estimated that drafting one of these things costs something on the order of $720,000 in 2015 dollars. And in addition to that, reviewing these regulatory impact analyses is also expensive. And it takes agency staff, it takes staff at OIRA to do these well. And note that OIRA resources have declined throughout time. I think at its high water point, it had something like 90 people in it. Now it's something on the order of probably 40 to 50 members. And if you want to increase the review, you've got to increase FTEs at OIRA and other agencies. So the bottom line, I guess I want to emphasize is if your interest, again, is in producing high-quality CBA, I want to submit that you should not only be focusing on Congress and the courts, but also the president and his political appointees and agency leadership. After all, judicial review under a statute only matters for a tiny fraction of the regulations produced by agencies. Internally, the agency leadership will often review most, if not all, of the rules that are likely promulgated, or certainly before they go to OIRA. 500 to 600 of those regulations are reviewed by OIRA because they're significant. And only 20% of those significant rules are economically significant, which is the study of this study, of the topic of this study. So Jerry and Reeves' valuable study gives us just a peek into a sliver of the practice of agency cost-benefit analysis. And in reality, the scope of the cost-benefit state is actually much, much broader. Thanks.
So now we're going to have reality therapy. Connor is going to describe the situation from the position of the agency that has all these pressures coming down on it in the benefit cost sphere and how agencies have dealt with these pressures. Connor?
Well, thank you, John. I'll try to deliver a little bit on that. And thank you, John, for organizing the panel, and to Adam and Leah for organizing this great event. Before I continue, I should just echo Jerry's government disclaimer. So I really like this project, and I think it's an important subject to think about specificity of procedural requirements and how they play out in practice. And I think it's important this time of reform as we think about regulatory reform. So it's a timely and important project. I generally buy the result, but I think I just want to talk a little bit about some alternative mechanisms or explanations that may also contribute to the result that the paper doesn't currently discuss. And I think the big one is we should think a little bit about what motivates Congress to assign specific cost-benefit requirements when it's drafting its statutes. And one of my beliefs is that Congress, and maybe this is naive and optimistic, but I do think Congress writes more specific requirements in contexts where it would be useful and feasible to do so. Now, politics may play a role too, but I think that feasibility and usefulness is important. And so part of the result may be that Congress is assigning these more specific and demanding requirements in cases where agencies are better able to do the job. And as you probably know, the science of cost-benefit analysis, such as it is not equally developed in different areas. So the Army Corps of Engineers has been doing this since the 1950s, 1960s. And environmental regulation has been done a long time, but in the area where I work, financial regulation, it's actually relatively new. And that may seem a little counterintuitive because financial regulation is seen as quantitative, but it's really an area that's lagged. And there are other areas that have lagged as well. And so there's this big debate in recent years about whether or not cost-benefit analysis is equally feasible in the financial realm, even if the science improves. And regardless of what you believe about that debate, it is indisputable that financial regulation is further behind environmental regulation in developing CBA techniques. That's just true. And so it'd be worth thinking a little bit about the mechanism process, the assignment process for when Congress tasks agencies with writing these things, even just in a qualitative way, because I think that may be driving some of the results. Now, I think OIRA is also part of the story. OIRA, in this sample, is reviewing every rule. And I should actually say, too, my remarks today are really focused on Jerry's half of the paper, which I really like. Reeves' part of the paper is an important part, but my focus is on the second part. And in Jerry's part, in that second part, every rule has been reviewed by OIRA. And I think it would be interesting to expand the study. I know it's easy to say gather more data rather than doing it, but it would be interesting to look, as folks have said, at rules issued by independent agencies that are currently not subject to OIRA. It would also be interesting to look at whether or not these results hold for rules that are not within OIRA's purview because they're not economically significant or otherwise significant, and see if the result holds. And I suspect, but I defer to the OIRA folks here, that OIRA may actually be harder and more searching in its review of rules where cost-benefit analysis is feasible and may push agencies harder in that realm. The paper hints a little bit at the courts and litigation risk. And the idea is, Reeves' section of the paper suggests that when statutory requirements are more specific, that courts are going to review more searchingly, more with less deference. Although, Reeves says there's a lot of noise, especially in the middle. It would be interesting in Jerry's part of the paper to have a more refined, rule-specific measure of litigation risk. And in particular, to see for these 130 rules, how many were actually challenged in court at the end of the day. And pop that variable in the regression, and that might be a much more refined test of litigation risk, which the paper sort of hints at, but we don't really have a great measure of right now because other than, of course, the measure of the specificity of the CBA requirement. And so I think those are some explanations that I think are plausible and the paper would do well to address. The other thing is something Reeve specified, which I like a lot, which is how narrowly tailored is the CBA, the cost-benefit requirement? Does it apply to a full agency? Does it apply to an agency's program? Or does it actually just apply to a specific section of a statute under which the rule at issue is being issued? And I think that would be an interesting variable, again, painful to code, but interesting variable to look at. And if we're really getting specific, do agencies do a better job as opposed to broader requirements like the SEC's ECCF applied to whole entire statutes, like the Exchange Act or the Securities Act. I suspect that your result would hold, but if you found it in that level of detail and that additional context, I'd be even more convinced. So those are just some thoughts on the paper. I just want to shift gears briefly. I want to leave time for folks to speak and ask questions, but there's this big debate in recent years about whether or not it's a good idea for courts to review cost-benefit analysis from agencies in a searching way, or whether or not courts should be deferential to agencies. And my strong view is that to the extent courts review, and I think OIRA is a better reviewer than courts. I think OIRA has more expertise. I think OIRA can engage in a dialogue with agencies rather than just setting a rule up to be vacated and remanded, or potentially just remanded. But I think OIRA is better institutionally situated in its place in the policymaking process. It engages at the proposal stage early on when the agency can shape the release for public comment. So I think OIRA is a better reviewer. If I ran the world, OIRA would review every agency, this is just me, and there would be no judicial review of any CBA. That's how I would structure the world. And the reason is, I think OIRA has a lot more expertise. I also think CBA is difficult for courts because by its own nature, it really cuts to the heart of the policy and political disputes in a rule. So I think courts can evaluate procedural violations, they can evaluate statutory authority questions, statutory interpretation questions, and while politics certainly can get infused in those, I think the threat of it is even greater in the cost-benefit context by the nature of the exercise of CBA. And my own take is some of these cases that have been alluded to where courts have overreached in the CBA context, I think that's part of what's going on, is that the politics and the policy are just so imbued in cost-benefit. And in addition, as I said, I think Professor Pierce earlier today mentioned agencies doing something day in and day out. The SEC has about 140 people in its mini OIRA, actually more than OIRA. And I think while we're not perfect, I think we do a better job than 3 judges and their law clerks who are jumping in this on a sporadic basis. And so I think to the extent courts are reviewing, they should be deferential. So thank you, and I look forward to the discussion.
We're going to shift to a phase now where we have discussion among the members of the panel, and then we'll try to leave room for questions at the end. But as we launch the stage, I just want to repeat for the audience, the paper seems to me reaches empirical conclusions that the courts have taken specific statutory language very seriously when Congress has given an agency clear directions about how it wants costs and benefits considered. But that when the Congress has not given specific language, the courts have treated a loose standard as an open-ended invitation to apply as rigorous or as lax a review of the rule as they deem appropriate under the circumstances, given what how the issue strikes them and what the advocates have raised in the case before them. It seems to me that these empirical findings provide useful information that the Congress could draw on in considering which, if any, provisions it wants to draft about cost-benefit analysis. But the policy takeaway from the paper is that there are 2 potential audiences in Congress. As Connor just said, there are the authorizing committees who pass laws for a specific agency or a specific program within that agency on a case-by-case basis. And the second audience is the Judiciary Committee and other people who are interested in general revisions to the Administrative Procedure Act. These are entities that have to draft general language because the situation at the Small Business Administration is going to be different from the situation at the Transportation Department. They can't draft with anywhere near the specificity because they're speaking to a range of agencies, 100 agencies or more, that are in the rule drafting business. So what that seems to me is the problem to date is that the action has been in the body, the Judiciary Committee and others who are looking at adopting the general rules. And so the takeaway from this paper is it's going to be difficult for general language to introduce a greater degree of rigor in here. If there's going to be a greater degree of rigor, it's likely going to have to come from the authorizing committees acting separately. That's my takeaway, but I'd be very interested in hearing others' reactions to the paper generally and the discussion today so far. Who would like to begin?
I have a question for Reeve.
Sure.
So on the theme of relative expertise of reviewers, I was wondering in your study of judicial review of these cost-benefit analyses, whether you noticed any variation between the DC circuit versus other circuits, because the hypothesis would be the DC circuit being more expert, seeing these more, is more searching, is able to grapple with these CBAs in a way that the other circuits aren't.
Sure. No, it's an excellent question. And unfortunately, since our sample size was relatively small, it would probably, I don't think we can really draw any overarching conclusion there, but I think just sort of thinking about in the abstract, going back to the cases we looked at, I think generally that sounds correct, that basically the cases where the review was particularly searching. Business Roundtable and a handful of other decisions did derive from the DC Circuit. So I think that's it's an excellent point, and it's another factor to consider here as well, particularly in the courts of appeals. I would also note we limit our review to the courts of appeals, so it would also be sort of interesting to see how this is played out in other courts as well.
Yeah, if I remember right, I think some of the careful ones might also have been out of the Fifth Circuit. And John, when you introduced Jennifer and you said there was another institutional player in regulation, I thought you were going to say the University of Chicago law faculty. But with some of the folks on that circuit, you would expect that some of those guys would give a pretty careful look at economic analysis of a regulation.
If I could also just briefly, as to John's broader framing comment, which I think is also an excellent point, and I think that's really a complexity that would be interesting to look at in the paper, and I think is sort of something that's going to be really significant to consider as these reform efforts go forward. So I think, yeah, first of all, it's absolutely right. Of the reform bills that we've tracked, virtually all of them tend to be cross-cutting, more the Judiciary Committee type thing. There are a handful that are agency-specific, not really any that I can think of that are sort of more program specific. So, I think that's sort of, in many ways, sort of the fundamental tension in the paper. That on the one hand, the ideal would be if Congress could provide this sort of more detailed direction. And I think Connor in his comments is absolutely right that it probably depends in part on sort of what the expertise of the agency is and sort of how effectively it could actually go about parsing this type of information. So that would obviously be the ideal, that it be program specific or agency specific. But on the other hand, this may be much more difficult from a political perspective, and that's sort of not what we've seen, at least thus far, with respect to sort of the major cross-cutting bills. One other point I would note on that front is, so the focus today is on this paper, but Jerry and I wrote a previous piece, the one I alluded to, coming forth in the Administrative Law Review, where we didn't at all look at the question of what the specific economic analysis standard would be. We sort of punted on that and looked more at the question of what goes into a regulatory impact analysis and what sort of how should the court treat that? Should it be part of the overall rulemaking record? And it seems to me that sort of cross-cutting reform, though it probably can't be divorced from an economic analysis requirement, could also be useful to sort of define the basic elements of a regulatory impact analysis and sort of what the status of it would be that becomes part of the overall rulemaking record. That might lend itself more easily to sort of a cross-cutting reform as opposed to the agency-specific or program-specific reforms where I think at least our findings accord with all of the comments today that ideally it's more specific, and I think that's much easier if it's at a more granular level.
Jennifer, I have a question for you. How much does OIRA consider in its review of benefit cost analyses the ability of the agency to defend it in court? I know they're not lawyers and they're not making specific provisions, but does that ever factor into the OIRA review, which is whether the agency has provided enough information to be able to withstand the challenges that you think may be coming from reading the sort of the other side of the equation? How does that work?
Yeah, no, that's my sense. I mean, I do think that OIRA, when it conducts its review, does have in mind the extent to which this could be struck down by court because, the president, like, the agencies, wants their regulations to be upheld in court. So I do think that is part of the factor, one of the factors that they consider. Just to connect it up to something that Reeve and Connor and others have pointed out, I do think that they also, and others should correct me if they have different impressions, but I also do think it is a factor that's considered is the capacity of the agency to conduct these kinds of cost-benefit analyses. In other words, I think they are much more deferential. There's a much more light touch on agencies where there's just not that many economists, or there's just not that much capacity to do much better than they've submitted.
Let me ask Connor a question as well. I don't know if you could speak to this, but within the SEC itself, over the years, as more and more attention has been focused on benefit cost analysis, has it been your experience that has the agency changed its approach to that? Have they been able to find more resources for it? How has that actually worked within the confines of an agency which has been the subject of several of the major court cases?
Well, to Jennifer's point, Congress has played a role here in earmarking or ring fencing a rather large amount of money specifically for the Division of Economic Research Analysis that does this. And so they've grown a lot. The money is theirs. And so that's been a big part of it. As some have noted, the agency has done staff guidance on economic analysis, internal procedural guidance as well about how we work. So things are a lot more formalized. I think there's been a process of getting the economists more professionally invested in this sort of work. And I think the agency has improved. In fact, Jerry has a report card that gives us markedly improved.
It's noticeably improved.
Markedly improved. I got Jerry right here, so I want to use the right words. More generally, the SEC as well as the CFTC have done better especially in the DC circuit, on cost-benefit analysis in the last 4 or 5 years. So, of course, there are other things that you could attribute that to, but overall, I think there has been a major change, and I think the product is better.
Well, thank you. Your comment leads directly into another question I have about this, which about the proposals that have been floated to modify the ABA. You heard references in the panels this morning to the Michigan v. EPA case, where it looks as if the Supreme Court is moving toward a situation where a failure by an agency to consider costs and benefits would be considered arbitrary and capricious. And the comments that we've heard from the empirical results here, that when the agency simply has to consider costs and benefits, you get a high degree of malleability in the effective standard of review that's applied to it. My question is, Connor's agency obviously is moving by a gravitational force to take this more seriously. The other agencies probably are, because they see the handwriting on the wall with Michigan v. EPA. And I guess my question for the authors is, has this momentum that's built up between this change modified your views as to what provision of the APA might be considered in a general EPA rewrite that is something by the judiciary committees where the rest of the world is already moving in this direction? Is the real role of a general provision at this point more to accelerate and codify an ongoing trend within the agencies?
Yeah, so I think that's it's an excellent question. I mean, I think certainly the case law generally is sort of evolving in a direction where the courts are much more willing to sort of closely parse the underlying analysis, particularly with respect to the underlying benefits and costs. I guess sort of my reaction would be twofold. One, yeah, I mean, I think in some ways it would sort of just be, particularly with respect to what we proposed in the earlier paper, that the Congress explicitly state what goes in a regulatory impact analysis and then provide that as part of the rulemaking record. I think in large part, yes, that would just sort of be codifying what's already underway. With respect to the specific standard, though, I think in Michigan v. EPA, given that the statute is silent, that there's certainly some evolution in that case law towards sort of an implicit requirement, if you will, in the APA that there still be some consideration of benefits and costs. I think it probably affects less the cases where there is some sort of specific statutory standard, which are the ones we were looking at specifically in this paper. So I think there's probably still some benefit in this sort of ideally more precise, more case-specific articulation of what Congress has in mind, both in terms of bringing greater consistency to the judicial review and greater guidance to the agencies. But I think, the overall point, I think, is absolutely right, that in some sense it's just sort of codifying or statutorily recognizing sort of the trends that are already underway in the case law.
All right. Thank you. Are there other questions or comments from the members of the panel? Well, hearing none, I think it might be time to turn to the audience for questions.
Hi, Richard Williams. To Connor's point, we have had over 35 years now a review by OIRA, and two products from Mercatus sort of come to mind. The first is a regulatory report card that Jerry mentioned, where the average grade for regulatory impact analyses, if you use schoolyard grades, was an F. The other one was between 2003 and 2012, there were over 37,000 regulations. Of those, only 115 of them had quantified costs and benefits. So I don't think we can say, well, OIRA is sufficient, and I don't think the movement is fast enough, even given what's going on now. So I just like your comment on that.
I guess my quick response is just to echo what Jennifer says, and I've heard Jim Tosi and others say, which is OIRA's and full-time equivalence is half of what it was at peak. And so I think your comment is largely should be addressed to Congress, and it's a more matter of resources than the appropriateness of institutionally of OIRA versus judicial review.
Great. We'll come here, and then I saw David Rosker's hand up next.
Richard Belzer. As a former OIRA economist, the fact that I haven't read your paper doesn't mean I can't criticize it.
I know that, Rick.
Yeah, I was going to point out, though, if I recall correctly from the data, this is a process judgment, a process quality data, and not substantive quality. And so when you give a regulatory impact analysis a high grade, it's about process. It's not about the actual quality of the underlying analysis, which I don't think is actually reviewed that carefully. Quality meaning like accuracy or something like that. So that matters, I suppose, because there's a fundamental difference between simply doing analysis and doing it well. And a lot of the agencies that don't do it at all, one reason they don't do it at all is that they couldn't possibly do it well. And other agencies that do it a lot could do it better. I think that's Richard's observation, is that the quality in terms of accuracy of the work hasn't improved that much over 35 years. But I would point out, I think that if you looked at the resources that are devoted to regulatory analysis, probably EPA's investment in analysis for the National Ambient Air Quality Standards, the dollar commitment to that analysis is probably as high as all other regulatory analyses combined, and yet the statute prohibits the consideration of cost for decision making. Do you have any insight on how that fits into your results?
Well, let me try and address two questions. One was about what do these scores evaluating the quality of analysis for regulation really tell us, and the other was the EPA question. And if I forget the EPA question, come back and point out that I didn't answer it. No, I don't think it's accurate to say that the score data we're using is just process scores and it doesn't really evaluate quality. But I think there's a gradation of ways that you can evaluate quality. And at one extreme of the spectrum is a checklist that where you look and say, is something present or not? So is there a number for costs? We're not going to ask if it's an accurate number, but is there a number for costs? Is there a number for benefits? We're doing something much more detailed than that. The other extreme is pretty much something you can only do with a case study method, where you take an individual regulation, read all of the relevant literature that's out there, whether it was used by the agency or not, and then try to assess whether the analysis done by the agency is well grounded in everything that scholars know about this topic or not. And some people have done some good case studies of those. And the evaluations that we did certainly did not do that. It's more of a middle ground where we are looking at some qualitative factors, such as, when you're talking about benefits or costs or the nature of the problem, did the agency articulate a logical theory that explains what's going on, what caused the problem, or how might the regulation create benefits? So, is there a theory that satisfies some basic logic that doesn't contradict basic tenets of economics? And is there some actual evidence cited? And, does it seem like fairly thorough evidence, or is it like, a before and after comparison of two numbers? So it gets part of the way to a qualitative comparison, but I agree it's not nearly as deep as essentially the evaluator becoming as much of an expert in the area as the agency is, and then trying to evaluate what the agency did. On the EPA question, what was the question again?
For national ambient air quality standards, EPA is forbidden from considering cost. Yet EPA invests an enormous amount of resources in estimating costs and benefits for those rules, even though they are prohibited. And I suspect, don't know this, but I suspect that the resources they devote to these rules is as large as all other resources devoted by the government to regulatory analysis combined.
Oh, okay, yeah. Our variable that codes regulations based on whether the agency's prohibited from considering costs. That's basically the NAAQS standards. And what we find on that after controlling for, agency-specific fixed effects and all kinds of other factors is that the cost analysis for those regulations is less thorough than you would expect after controlling for all the other factors that might affect cost analysis. The explanation of how the analysis was used is actually less thorough than you would expect. But the analysis of benefits and the underlying problem actually seems to be better. So it looks like what's going on in those cases is a big chunk of the investment that EPA is making is in coming up with the benefit analysis in order to sell the regulation. In order to sell the regulation, that's my speculation of one reason why you might do, make a lot more effort into doing a benefits analysis, because it makes it easier to convince everybody the regulation's a good idea.
Thanks for that observation. I'd like to try to get in the question from David.
Hi, Dave Rosker. I'm Office of Advocacy, but a former Iranian. Jennifer's challenged me, and I've got a dozen things, so we'll try and figure out what I want to ask. The first is on the question of OIRA as evaluating litigation risk. And I would like to just put a spin on that to say that OIRA has its institutional interests, and its institutional interests go towards more analysis and more data. That's sort of the staff institutional interests. Where litigation risk comes up is where OIRA staff can leverage someone else's perception of the litigation risk to get more information into the docket. And so even though OIRA itself won't hold anything up for litigation risk, they will say, well, under, say, the Reg Flex Act, you haven't done enough analysis, so put more analysis into your docket. OIRA as an institution is always dealing with triage, trying to figure out where to put its resources to its analysis. And so my question for Jerry is, to what extent is the scale of the regulation, the amount of costs, a factor in how good the analysis is? Because in the same way that OIRA and the courts and Congress may give an agency that doesn't have a lot of resources to devote to economic research a high bar to meet, so OIRA would spend more resources on very large rules and less resources on smaller rules. And the last is Michigan EPA was a finding that it was arbitrary and capricious to not consider cost in a very specific finding, the necessary and appropriate finding under 112. So my question is a court move to require greater cost-benefit analysis under rulemaking counter to Vermont Yankee?
Reeve, is that a question that has arisen in your consideration of the case law?
The Vermont Yankee, Michigan v. EPA point. No, not directly. I mean, I guess it's yeah, no, certainly something that would be interesting to grapple with. I'd have to give it some sort of additional thought as to sort of how exactly that would, both fit within the analysis. Yeah, I don't really have too much to
Right,
add.
but if, it strikes me as something that if people were working on the legislation or in the room, they'd want to make certain that that's covered in the legislative history, because it seems, the situation about Vermont Yankee has come up. I remember hearing it this morning about, I think it was in perhaps just Judge Kavanaugh's work. That's probably an important thing for Congress to decide on, and to try to lay out as best it can. So I think with that, we need to keep the group back on schedule. So I think, thank you for your patience and your attention today.